Good morning, everyone. My name is Michael Halsey. I'm a partner in the employment team at VWV, and I'll be going through the webinar today about redundancy and restructuring. I'll be doing the first bit, and then my colleague Bob Fahy will be dealing with the second element. I think the idea is to take questions at the end, so please pop those in the Q&A box. So if we move on to the next slide, it's just a quick overview of what we're going to cover today. I'm going to deal with redundancy and restructuring, contrasting the two, and formulating a business case. Then Bob's going to run through a fair process and talk about risk mitigation. And as I say, at the end, we'll cover some questions that you may have. So if we move on to the next slide. So the first slide we're going to cover, or first topic we're going to cover, relates to redundancy and restructuring and really contrasting the two. So redundancy and restructuring are often rather lumped together, perhaps even used interchangeably as terms. And there may be some good practical reasons for that. For example, it's telling an employee they are being made redundant is a very clear and understandable message often. However, as lawyers and as HR professionals, I think it's important to know that the law has a particular view about what a redundancy is, and some dismissals arising out of restructuring processes will not satisfy the test of being a redundancy. It's also important to remember that what will amount to a redundancy and what will not is very fact sensitive, and this makes it difficult to draw hard and fast rules about what will apply in every case. So this first slide sets out some high-level themes that apply to redundancies and restructuring or reorganizations. So looking at the redundancy side, first, obviously there's a statutory definition of redundancy. I'll come on to talk about that in the next slide. It says here redundancies will reduce headcount, and that's nearly always the case. But it's important to note that it's not always the case, and I'll have a nod to that when we cover the next slide. They will involve individual and potentially collective consultation. Redundancy is a fair reason to dismiss, meaning that as an employer, you'll be protected from unfair dismissal claims as long as you followed a fair process. And Bob will talk about that a bit more as we go on. And importantly, of course, if people's dismissals amount to redundancies, then they're entitled to a statutory redundancy payment or potentially a more generous contractual payment if you operate those schemes. Looking at the restructuring column, there's no statutory definition of restructuring or business reorganization, and it has a wider meaning than the statutory definition set out in redundancy. It's perhaps less likely to lead to reductions in headcount, but it may well do so. Can include situations where there's a proposal to change terms and conditions, where that proposal falls short of fulfilling the statutory definition of redundancies. In common with redundancy, it's likely you'll need to follow individual and potentially collective consultation if terminations are possible. And again, in common with redundancy, following a dismissal following a business reorganization can be fair under the head of some other substantial reason. Well, when I say it's got in common with redundancy, I should say that what it has in common is that there's a potentially fair reason. Obviously, the potentially fair reasons are different. Unlike redundancy, of course, if an employee is dismissed following a business reorganization or restructure that falls short of redundancy, then they will not be entitled to a redundancy payment, only to their notice pay. So moving on to the next slide, which is what is a redundancy? And I'm going to look at the statutory definition of redundancy, and that's set out in section 139 of the Employment Rights Act 1996 and is summarised on this slide. I'm going to look at the statutory definition in a bit more detail because I think it's pretty important to cover it off. So the first element relates to business closures and workplace closures. And what section 139 says is that an employee who is dismissed shall be taken to be dismissed by reason of redundancy if the dismissal is wholly or mainly attributable to the fact that his employer has ceased or intends to cease to carry out the business for the purpose of which the employee was employed, or to carry out that business in the place where the employee was so employed. So I think that's fairly clear cut, although it may be complicated occasionally by mobility clauses in the contracts of employment of the affected employees. The third bullet point there, and the next part of the statutory definition, relates to the reduction of work of a particular kind. And that reads as follows: for the purposes of this Act, an employee who is dismissed shall be taken to be dismissed by reason of redundancy if the reason is wholly or mainly attributable to the fact that the requirements of the business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where the employee was employed, has ceased or diminished, or are expected to cease or diminish. Now this element of it can be rather more complicated and is perhaps the more common element which people have to deal with. For example, is an employee redundant if they're dismissed having failed to agree changes to terms and conditions? The question will be whether the changes in terms and conditions went as far as to reduce the need for employees to carry out work of a particular kind, and that's quite fact sensitive. And the case law shows how fact sensitive that can be, and can be quite confusing as a result. So a couple of quick examples. So a school employed 2 plumbers to do general plumbing work, and then the school was lucky enough to have a new heating system installed which required more specialist heating technician work. So the school dismissed one of the plumbers and hired a more specialist heating technician. The courts held that this was a redundancy because of the change in the duties and skill set of the individuals, or of the jobs. However, in another case, an NHS trust merged its cardiac and its thoracic departments, and a thoracic surgeon was dismissed for refusing to take on some cardiac work. That dismissal was not held to be a redundancy, even though the tribunal accepted that cardiac and thoracic work were held to be different. So at first glance, it's difficult to tell the difference between those two cases. Case reports show that really the difference lies in the detailed findings of fact by the tribunal. The final element on the slide says that a reduced requirement for work of a particular kind could mean less work and fewer people required, or the same amount of work but fewer people required. I think I should add that there needs to be a third bullet point there of cases where the number of people stays the same, as in the plumbing example I gave above. So in that case, there were 2 individuals before the new heating system was installed and 2 after. The key to that case was in the changes to their skills and duties. So that's the statutory definition of redundancy in the Employment Relations Act. My mind's gone completely blank for a second. In the 1996 Act. So I should also cover the definition of redundancy, cover the fact that the definition of redundancy changes when looking at collective consultation. So section 188 of the Trade Union and Labour Relations Act states that collective consultation will be required where the employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. Redundancy for these purposes has a much wider meaning than it does in the statutory definition set up on the slide. It's defined as dismissals not related to the individual's concern, so for example, not related to their conduct or their performance. This will include redundancies under the Employment Rights Act, as set out on the slide, but will also include other redundancies arising out of restructuring or reorganisation processes. For example, dismissals arising out of a refusal to accept changes to terms and conditions. Bob's going to have a look at that definition in a little more detail further on. So moving on to the next slide. What is a restructure or a business reorganisation? Generally speaking, these are changes to organisational structures, for example, reporting lines or terms and conditions of employment. Where employees object to a proposed restructure, it can become necessary to terminate their employment and offer re-employment on new terms. This is a controversial practice, and dismissal should only be considered as a last resort. It used to be called dismissal and re-engagement, but after quite a lot of recent controversy, it's often referred to as hire and refire. If dismissals do take place, they may or may not satisfy the definition of redundancy under the Employment Rights Act. For example, they may not satisfy the definition if there is no reduction in the need for work of a particular kind. If dismissals do not satisfy the definition of redundancy, they can still be fair under the heading of some other substantial reason, as long as a fair process has been followed. Okay, moving on to the next slide. This sets out a short extract from an EAT judgment, which looking at whether a dismissal following a restructure will always be a redundancy. So I'll just read it out quickly. It is not an automatic consequence of there being a business reorganisation that there is a redundancy, nor is there a need for a business reorganisation in order that there should be a redundancy situation. The two are entirely self-standing concepts. But if a business reorganisation leads to a diminution in the requirement for employees to carry out the relevant work, then that business reorganisation leads to a redundancy situation. And if not, not. I think that's pretty clear, although it is a bit legalistic, but hopefully that's a helpful quote to summarise that part of the talk with. So moving on to the next slide, which is about formulating a business plan. This is advisable whether you're entering into a redundancy process or a business reorganisation, for example, a change in terms and conditions. I can see that there may be more than one document setting out a business case. For example, there may be briefing papers to the board or management team, as well as documents setting out proposals to members of staff. It's likely there's also be sort of precursor documents, email exchanges and other documents discussing the issues involved. Ideally, all of those documents are going to be consistent and objective, as they may become disclosable in the event of dispute. This slide sets out some of the key reasons why it's important to have a written business case or set of proposals that you can share with the affected employees. I think the bullet points identify two key themes. First is putting something in writing helps to test the business rationale in advance of communication with the workforce. And the second is that a written document communicating proposals to the workforce will be a crucial piece of evidence in the event of a dispute further down the line. Moving on to the next slide. Whilst the form of a business case may vary depending on the size of the employer and the particular circumstances of the case, there are certain topics that it should try to address. And we've tried to summarize some of these on the slide. So the first is what efficiencies or savings it is necessary to achieve. So what is the objective that's trying to be achieved? What is at stake? Providing the financial information can be very helpful and will help identify what the underlying problem is and make it understandable for the workforce. It's important to set out what the proposals are and how the proposals achieve the aim. That's not always easy, but having a clear logical sequence from the proposal to achievement of the aim can really be helpful, both for the employees involved and if it ends up in dispute at the end of the day. And finally, what process will be followed? For example, are there individual or consultation or collective consultations? I think we find it very helpful if there is a timeline set out, which might set out the various stages which you go through and an intended final date, although obviously that may need to flex as time goes on. Moving to the next slide. Sets out various other factors to bear in mind when formulating a business case. First one is there a redundancy policy to factor in? And of course, that's vitally important. I know many of you will have redundancy policies, and you need to follow those. If you don't, there's certainly a much higher risk of any dismissals being found to be unfair. Who will the decision makers be? Obviously, that's important, just so people in management know, but one of the other key things to think about is having a layer of senior management left apart from the process who can deal with an appeal. What alternatives to the proposal have been considered and why are they not viable? So that's going to be a thought process that you go through probably prior to communication with the workforce. But I think communicating the thought processes in this regard can be helpful because it can help streamline consultation processes. Alternatives to redundancy might be other ways of reducing headcount, for example, restricting recruitment, deferring new joiners, or redeploying or seconding staff. You might also have considered reducing hours or reducing remuneration. That may be much more viable in smaller employers potentially than in larger employers where there may be collectively agreed terms, etc. How can the impact of the proposal be mitigated? Consider voluntary redundancy, alternative employment, and any other mitigation. So these are things which are likely to need to be communicated in the business case to the workforce. And one of the things I think most people will consider when communicating to the workforce is whether there'll be an offer of voluntary redundancy. It's important to think in advance about what the terms will be, whether they'll be attractive to people. And the other thing that's important about voluntary redundancy is making sure that you have the ability to refuse volunteers, because of course you can't guarantee that individuals who would be retained under a redundancy selection process or other reorganization, if they volunteer, then you may need to refuse them for their core skills or duties. In relation to mitigation, where there is a business reorganization, for example, changing terms and conditions, one of the things you might consider also is a transition period, particularly if the changes to terms and conditions affect the pay or benefits that individuals receive. And finally, of course, when you formulate a business case, it's important to think well in advance about the costs involved. Cost of redundancy payments, notice pay, potentially legal fees if you need to take advice on the way, and any other costs. Those other costs might involve potentially the costs of providing settlement agreements if you want to close things off in that way. Okay, so that's where I'm going to finish up talking about formulating a business case. I'm going to move on to Bob now, who's going to talk about running a fair process.
Thanks, Michael. Good morning, everyone. I'm Bob Fahy. Like Michael, I'm a partner in the employment team here at BWB. And as Michael says, I'm going to cover now a discussion about fair processes and ways to mitigate risk. I'll talk about minimizing risk as I go along. And then in the last couple of slides, I'll try and sort of sum up some of those conclusions at the end. Couple of preliminary points I'd like to make is, firstly, redundancy processes, particularly where they involve both collective and individual consultations, can at first seem quite daunting. But really, if you take nothing away from this webinar, then one message, the point that I would emphasize is that if you have a well-structured plan and you follow that plan through methodically, you can go a really long way towards minimizing your risks and making your own lives easier. And before I get into the specifics, the other key point I'd like to emphasize is that in restructuring and redundancy situations, you can actually have as many as 5 potential options for your procedural requirements. So these would be an individual redundancy consultation alone, a collective redundancy consultation followed by an individual redundancy consultation, a non-redundancy restructure that requires individual consultation for some other substantial reason only, classically a hire and refire, a non-redundancy restructure that requires collective consultation first, followed by that individual consultation for, or a general restructure where there's no legal consultation obligation required at all. And again, if that sounds daunting, don't worry, we'll go through all of them piece by piece and fit the pieces of the puzzle together. It's also important to keep at the forefront of your minds that the primary purpose of each type of consultation, if, for instance, if you're relying on some other substantial reason in a fire and rehire type situation, or if you're relying on redundancy as per the definition Michael gave earlier, the individual consultation is part of the requirement for a fair dismissal. So that's legally the key purpose of your consultation process. The purpose of collective consultation, as Michael says, is to comply with the requirements of section 188 of TOLCRA, and by doing so, minimize the risk of protective awards for breaching those requirements. So those are kind of your legal underpinnings. Of course, consultations will generally involve engaging with your workforce to make the process as smooth as possible, and there'll be broader implications outside of those legal requirements. But do keep in mind those key legal underpinnings why you're doing the consultation process. As Michael has said, a key part of formulating your business case will be identifying which of these situations you think applies to you, starting with the question, are we proposing to dismiss 20 or more employees over a 90-day period at one establishment for reasons not relating to those employees? And when we say that broader definition of collective consultation redundancy, reasons not relating to the employees means reasons other than things like the employee's own conduct or the employee's own capability. Those are reasons that relate to them individually. Whereas if you've got a broader change applying to what you need from your workforce, those aren't reasons that apply to them individually. So that question will tell you whether you need to engage in collective consultation before you undertake individual consultations. You should also remember that in any collective consultation situation, you're required to submit a Form HR1 to the Department for Business, Energy and Industrial Strategy, notifying them of the proposed redundancies, and that has to be done within the same timescales for starting collective consultation as set out on the slides. And you must also copy that notice to the relevant employee representatives at the same time. So if we move on to the next slide, please. Once you've established whether you have a collective consultation obligation or not, it's helpful to prepare a proposed consultation timetable, do bear in mind that there will need to be a degree of flexibility in your dates in your timetable, as in the case of collective consultation, one of the key statutory obligations is to commence consultation with a view to reaching agreement. And one of the key elements of fairness for an individual consultation, whether redundancy or some other substantial reason, is to avoid prejudging the outcome from the start of the process so that you're properly engaging with what your employees say in the individual consultation. Now, a rigid time frame is not in itself proof of prejudgment, but it is something that we often see both individuals and employee representatives, whether trade union or not, seeking to frame as indicating that you've entered into the process with closed minds as to the outcome. So a degree of flexibility in your time frame is often a helpful thing to have. If you do have a collective consultation process, you'll need to build time to carry that out before you start individual consultations. The minimum statutory timeframes are to begin consultation and that's done by providing the necessary information to the representatives at least 30 or 45 days before the first dismissal is proposed to take effect, depending on your numbers as per the slide. And that's based on when the dismissals are proposed to take effect, not when the first dismissals actually take effect. So you might actually have some volunteers for redundancy in a collective process that end up leaving earlier than you had planned. That wouldn't put you in breach of your obligations by starting 30 or 45 days before what you had proposed at the outset. There's also a general obligation to start consultation in good time when you're consulting collectively, which essentially means soon enough before the dismissals take effect to have a reasonable prospect of reaching agreement with both parties, assuming both parties are acting reasonably and without undue delay. That's not to say that there is an outright obligation to reach agreement, but what you have to do is engage in a process that's akin to negotiation rather than simply both sides presenting their views and then bringing matters to a close. So that you need to show a proper degree of engagement. Another point that I think is worth mentioning is that in recent years, I've seen a number of representatives, particularly trade union representatives, trying to argue that an employer must begin a collective consultation as soon as it has formulated its proposals that could potentially lead to 20 or more dismissals in a 90-day period. Now, that's not the case. The only timing requirements are those that I've just mentioned. However, it is important to bear in mind that one of the hallmarks of fair collective consultation is it's begun when proposals are at a formative stage. So it's about being open and properly engaging with your consultation partners. If you have a recognised trade union, or probably a bit more unusually a standing body of representatives that are not a trade union but who are recognised for the purpose of redundancy collective consultation, you'll be able to begin the consultation as soon as you are ready to provide the statutory information. If not, you'll need to build in an additional time to facilitate the nominations and elections of appropriate representatives of the affected employees before you actually start the process of consulting. You're required to consult collectively on ways of avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of dismissal. So those 3 points are the only points that are specifically mentioned in section 188. But case law also makes clear, and you'll probably be familiar with the case of Williams and Compare Maxim, that says that where there is a recognised trade union, you should consult with it over any proposed selection criteria, and where criteria have been applied, the fairness of their application to get the union's agreement to those two elements of your proposals. And in that regard, I think from an employer or HR perspective, it is easy to see collective consultation obligations as a duty to fulfill, essentially. What I would say is it also presents a real opportunity to set up a smoother individual consultation process and minimize the risks associated with the individual elements of consultation. In particular, if you've managed to agree selection criteria and even the application of the criteria to specific scores with your trade union representatives collectively, it's going to be much harder for any individual employee to challenge the fairness of their personal selection in the individual consultation process. So there's an opportunity there as well as an obligation to go through. If we go to the next slide, please. So assuming you've successfully completed collective consultation, either by reaching agreement or reasonably exhausting the possibility of reaching agreement, or if you don't have a collective consultation obligation, then you'll move on to individual consultations. In the absence of collective consultation, that will first require you to identify the pool of employees who are at risk, decide whether a selection process will be required. If so, identify what criteria you will apply and how you will score them, including any weighting of key criteria. If you've got collective consultation, you'll have gone through that with your representatives. You should also plan who will apply the criteria, as Michael's mentioned, and ideally that would be two managers who have sufficient knowledge of the employees to fairly apply the criteria and whose scores can be collated to create an average score. In smaller organizations, that's not always possible, and you are permitted to fit your consultation process to the size and resources of your organization. But ideally, having two managers and a collated score is a fairer way of going about things. You may also want to seek volunteers, as it says on the slide, usually in return for an enhanced redundancy package. And if you're going to take that approach, you will want to factor in the time necessary to make those offers of voluntary severance and deal with responses before you actually begin consultation on compulsory redundancies. And then for the consultation itself, as mentioned on the previous slide, there's no fixed timescale set out in law for individual consultations. There was a case in 2007 where the Employment Appeal Tribunal upheld a consultation process as adequate on those very specific facts that only lasted 7 days, but it did describe that as the bare minimum. And normally I would not expect a 7-day consultation period to be enough for a fair individual process. I think the important things to bear in mind are that you will need to give employees enough information and enough time to come into their consultation meeting and be in a position to comment on, and if they wish to, challenge their selection, but possibly including in terms of the pool you have chosen and the selection criteria you have applied. Also to put forward suggestions that they might have as to ways of avoiding their redundancy, and to discuss with you any proposals that you have for alternative employment. So with those topics for you to discuss, you're going to need potentially a number of meetings, sometimes only 1 or 2, but sometimes more. And you're going to need to factor in sufficient time in the consultation process to allow those discussions to take place. And then once individual consultations have been concluded, you should be in a position to confirm your decisions to dismiss, either give notice or pay in lieu of notice, and pay statutory redundancy pay, plus any other pay due on termination, such as holiday entitlement that has accrued but not been taken at the time of dismissal. So then moving on to the next slide, please. So now we're looking at restructures that are not individual redundancies. So in other words, we're not relying on the Employment Rights Act definition of redundancy, reduction or cessation in need for the employees to perform that kind of work. And in a restructuring process that's not redundancy, the process will depend on the nature of the changes you're proposing and the number of staff affected, because you might still have collective obligations. So for instance, if you're proposing a variation to terms and conditions, one option is to seek employees' agreement to your proposed changes directly without starting any formal consultation, particularly when numbers of staff that might be affected are hovering in the low 20s. This might be an attractive approach because you may be able to reach agreement with sufficient of them to move out of the collective consultation regime. And in this respect, bear in mind the wider definition of redundancy for collective consultation purposes. It's any reason not relating to the individual employees, as I said before, such as their conduct or capability. And that would normally include, for instance, a fire and rehire to change terms and conditions, because that doesn't relate to them individually. It's driven by an underlying business need to have different terms across your workforce. If you don't have a collective consultation obligation, but you're considering a dismissal and re-engagement as a means of enforcing changes to terms and conditions, there's still the need for fair individual consultation, just not within the redundancy individual consultation regime. So you'll need to have evidence of a sound business reason for your proposed change. And broadly speaking, a reasonable consultation process in this regard will involve listening to any reasons employees have for rejecting your proposed changes, responding reasonably to those objections, and where reasonable to do so, making concessions. And as with individual redundancy consultation, you'll need sufficient time to do those things, and that may involve a number of meetings, normally would. As Michael has mentioned, the law on fire and rehire, as we're now calling it, or dismissal and re-engagement, as we used to call it, has been in the spotlight. The current position in terms of statutory frameworks is that there's a proposal to introduce a statutory code of practice, which presumably will set out key requirements of fairness. And I imagine that most of you who are on the webinar or signed up to our e-zine will keep you up to date with any developments on that, so you know as and when there's any progress on those proposals. So if we move to the next slide, please. And the next couple of slides that I've got set out common areas of dispute and ways to deal with them. As I say, this is largely now a summary and recapping the points that Michael and I have already made. Common areas of dispute for redundancy. As mentioned, you might have challenges as to whether it's genuinely a redundancy situation, whether there's a genuine cessation in your need for employees to perform work of that kind. You may have challenges both at the collective level and at individual level to the selection criteria you've chosen, whether alternative employment is suitable, whether alternative vacancies have been fairly filled. So some employees may feel that alternative vacancies have been allocated to people other than them that should have been allocated to them, for instance. In a restructure, often there'll be a dispute about whether it's a redundancy in disguise because employees feel that they should be getting a statutory redundancy payment. The case actually that Michael mentioned earlier, the Kingwell case, was an example of that, where you had 10 part-time employees who had agreed to reduced hours because of financial pressure on their employer's organization. And then the 10 part-time roles were replaced with full-time roles, initially 4, and then during the consultation it was increased to 6 roles in total. And the employment tribunal said that wasn't a redundancy, because the tribunal said it's still the same amount of work being done, so there's no reduction, which is completely the wrong way to approach these things. And the EAT made clear that the question is, do you have a reduction in need for employees to perform that particular kind of work? And this employer's need had reduced from 10 employees to 6 employees. So that's clearly a redundancy situation. So just to illustrate the kind of challenge that you might have, and the need to get your thinking on that right. And finally, in a restructure situation, you might have challenges to the reasonableness of your proposed changes to terms and conditions. Now, as I say, what you have to show is only that there's a genuine business need. You don't have to show, for instance, that the change is critical for the survival of your business. The threshold is only that you have a genuine business need. But when tribunals are assessing whether a dismissal is fair under the substantial reason heading on a fire and rehire, essentially what the tribunal will do is balance the reasonableness of your need for the changes with the reasonableness of the employee's objections. So the risk mitigation exercise there is largely about the process and your engagement with the employees. So the better you have explained your need for the changes and given warning and time to engage, and actually engaged with the reasons that your employees are giving for not wanting to accept them, including to stepping back and assessing the impact on your employees of the changes you proposed and considering alternatives, then the better prospects you'll have of winning that argument ultimately. Next slide, please. And then I think this is largely a summary of what I've said already with a couple of extra points. So first and foremost, plan your process in advance. Use consultation timetables, plan meetings, and have your business case prepared in advance. As and when and if the statutory code of practice on fire and rehire is published, you should be adhering to it. And as I say, we'll keep you updated on that. Allow sufficient time so that the process is not rushed, so that you can't be criticised for not having properly engaged. And that's what the timing issues are about. They're not necessarily a factor in themselves so much as an aspect of showing proper engagement with either your reps in consultation, in collective consultation, or your individuals in individual consultation. Ensure consultation is meaningful. Demonstrate you've properly explored suggestions and responded to feedback. Engage with what's being said to you. Hopefully, obviously, keep detailed contemporaneous evidence of rationale in meetings. Bear in mind that the notes you take and the evidence you record would ultimately be disclosable in any employment tribunal proceedings. So make sure that it reflects accurately what is said and sets out your fair decision-making processes. Follow up the meetings in writing. Again, I think that's probably a fairly obvious one. Seek agreement, and that might, in a contractual variation situation, include seeking agreement before engaging in formal consultation. And particularly if you've got a voluntary situation where you're paying enhanced redundancy terms, consider the use of settlement agreements. So I think that works out timing-wise quite well. We've got just under 20 minutes now to deal with your questions, and I can see from the Q&A box that we've got plenty of those. So let's have a look at what people are asking. Michael, do you want me to take the first one and then we'll just run through them?
Sure, absolutely. We can chip in as we go.
Yeah, okay. Well, so the first question is, when would someone be dismissed under a restructure and it is not a redundancy? Okay, so conceptually, the answer to that is whenever you've got a workforce change that doesn't involve a reduction or cessation in work for employees to perform, a particular type of work for employees to perform. I think a really good example of this from a case that's probably 40 years old now, which kind of brought it to life for me, was when two employees working day shifts were dismissed and replaced by two employees doing exactly the same kind of work but on night shifts. The tribunal held and was upheld by the EAT that wasn't a redundancy situation because there was no reduction in the number of employees nor any variation in the type of work being performed. The restructure was about a shift pattern, which was not within the scope of the statutory definition. So hopefully that makes it clear. You can have restructures that involve termination of employment, and the other example was the one I've been talking about, the fire and rehire to change terms and conditions, which would be some other substantial reason, not redundancy. The next question, we have an employee whose job role is no longer required due to business requirements. However, there is an alternative role that we would like them to take on. Do we need to make their current role redundant, or can we speak to the employee, explain the situation, and see if they would be interested in this change before we go down the redundancy route? Michael, what do you think?
Yeah, so in those sort of situations, you'd expect to have discussions with the employee first, I think. So there'll be proposals that there might be a risk of change and risk of redundancy, but in this case, obviously, there would be a potential to redeploy them and avoid any redundancy. If they do get redeployed, then there isn't a redundancy. There's no dismissal. They simply start an alternative job. There are some statutory quirks around the ability to have a trial period and things like that, but there wouldn't be a redundancy if someone took up alternative employment. So looking at the next one, I just lost it there for a minute. If we are looking to increase working weeks from 39 to 52 weeks for all remaining staff on 39-week contracts, 6 or 8 employees, is this a straightforward variation of contract and or a restructure? And how do we go about it? Well, I think,
yeah, no, go on, Michael.
Yeah. I mean, I think this is one of those things that we mentioned at the start, how fact-sensitive situations are. And this is one of those matters which is likely to be dictated by the detail. But on the face of it, just changing people's working patterns or working hours may not amount to a redundancy, because there may be no change in work of a particular kind or any reduction in the number of employees involved. How do you go about it? Well, you'll need to follow a consultation process with the individuals, clearly, to try and get them to agree in the first instance. If they don't agree, then there'll need to be further discussions with them. And right at the end of the line of that, there will be the question of whether you dismiss and offer re-engagement on the varied terms. But that's very much a last resort, and tribunals will expect employers to be creative and flexible around transition arrangements and other alternatives in order to avoid the need for dismissal arising out of these sort of situations.
Yeah, I think we've taken it as read that those on the call will understand that you can't unilaterally change terms and conditions of employment of employees, and that agreement is needed. And if you can't get it, then only after sufficient consultation, as Michael said, as a last resort, is hire and refire an option that's open to you. So the question is this a straightforward variation of contract and or restructure? Yes, but yeah, the devil is in the detail. The next question is, what is the impact of changing reporting lines as part of a restructure, no other changes in terms and conditions? I will say a slightly lawyerly answer, it does depend. What it largely depends on is the strength, if any, of an argument that reporting lines are actually part of the employee's terms and conditions. And in many situations, reporting lines will not be part of a contract of employment, or it might be framed in such a way that it will be one of those situations where you might actually be able to vary it, vary a reporting line without changing the terms of the contract, if your contracts are constructed in that way. And if it doesn't form part of your employment contract, then you should be able to go ahead with a change in reporting lines without consultation. One caveat to that I will say, though, is that I have seen situations where employees who are told that their reporting lines are being changed without being consulted seek to challenge that as effectively a demotion, depending on the person who they're being moved to report to. So if it was someone who was previously a peer, for instance, I've seen employees who treat that as even a fundamental breach of their employment contract and seek to resign and claim constructive dismissal. So as with so many things, you have to look at the specific circumstances. But the general point is, if it's part of the contract of employment, then you'll need to consult about it and reach agreement. And if it isn't part of your contract of employment, then you won't need to.
Okay. The next one is, please, could you clarify whether takes effect means the date when the notice is issued or the date of termination of contract? And I think this relates to what Bob was talking about in terms of collective consultation, and generally speaking, takes effect in relation to collective consultation means the date when the contract terminates, not when the notice is issued.
Yes.
The next one after that is, if you recognise a trade union, but the individuals potentially affected by a redundancy process aren't members, do you have to go through a process of nominating other representatives? So this crops up quite a lot, doesn't it, Bob?
We were just dealing with this last week, weren't we, Michael?
Yeah. And I think it depends. If you're going through a process that requires consultation with representatives, for example, collective consultation, then whether or not the individual members of staff affected are members of the union isn't really the key question. It's whether the union is recognised for the purposes of collective consultation for that part of the workforce. If you do have a recognised union for that part of the workforce, then you'll need to go through those union representatives. It's only when you don't have a recognised union that you are then in a position to look at other representatives that may exist or elect representatives. Is that fair enough, Bob?
Yep, spot on. Yep.
Right.
The next question is, if a company recognises a union, is there an obligation to allow individuals to bring along union reps from other non-recognised unions to individual consultation meetings? Or can the company insist that union representation in these meetings can only be from union reps from the recognised union only? Okay, so the right to be accompanied by a trade union rep isn't limited to representatives from recognised trade unions. So there's plenty of employers who don't recognise any union, whose employees have the right to be accompanied by any trade union rep with the appropriate certification. So all you can really do is require the union rep to show that they are either a full-time employee of the union or a representative who has completed the appropriate certifications to accompany people. But the right to be accompanied on a statutory basis applies to disciplinary and grievance procedures and appeals from those, not to redundancy processes. And what I'm trying to remember and struggling for a bit, Michael, is whether there's been any recent developments about whether the failure to allow someone to be accompanied in redundancy consultations is now unreasonable or not. Certainly, no, it's nothing like that. So
no, I mean, I think it may not be required under the statutory right to be accompanied, but probably it's part and parcel of a fair process to allow people to be accompanied, or will be an element of that. And in the end, what you don't want is some sort of satellite argument about who's going to be accompanying. What you really want is to get the meetings to go ahead in accordance with your timeline and to address the issues, substantive issues about the redundancy, not to be arguing about who's in the meeting and who isn't. So I think I'd usually recommend quite a degree of flexibility on behalf of the employer, because it'll be very helpful later in the event of any sort of outstanding dispute on dismissal.
Yeah. The next there's two questions that are essentially saying the same thing, I think. So we've got, do you have to complete collective consultation before commencing individual consultation, or can you run the two concurrently? And can you confirm collective consultation and individual consultation can be undertaken in tandem? I've definitely had situations where the collective consultation process has not fully concluded when individual consultations have started, but you do have to be very careful in doing so. And the reason you have to be so careful in doing so is that your collective consultation obligations are to consult with a view to reaching agreement. And if the collective consultation is still ongoing, by definition, you haven't yet reached agreement. And so if you start individual consultations before you've reached agreement, or before you have shown that you have gone through a process of properly engaging with the representatives and reasonably reached a point where it is clear that despite both sides' best efforts, it's not going to be possible to reach agreement, then triggering the individual processes could put you at jeopardy of claims that you've breached your obligation to collectively consult properly. So it's certainly not something that you should do as a matter of right without giving it proper thought. And certainly I wouldn't be starting an individual consultation process at the same time I'm starting collective consultation, because then it will be quite clear that you won't have concluded or won't have undertaken your collective obligations while you're running your individual ones. Michael, do you have any different take on that? Or
no, that's I agree with all of that. And I suppose the other thing is that the 30 and 45-day period which has to elapse before the first redundancies take effect. It's entirely possible that you might conclude collective consultation in a much shorter period, particularly if there's nothing much to talk about.
Yes.
So in those situations, you can start individual consultation safely within that period. It's just that the first redundancies can't take effect until the end of that period.
Yes.
Yeah. So we're approaching the end. We've got a couple of minutes. So
quite a few questions left.
Quite a few questions left. I'm sorry we haven't been able to get to all of them. The next one is, what are the pitfalls of using a selecting in rather than a selecting out redundancy selection process, e.g. via recruitment selection process? So I guess that's the practice of putting everyone at risk and allowing people to apply for the vacancies in the new structure rather than selecting the individuals yourselves for the new structure, which, if I've understood the question correctly, I think that those are two alternative approaches, I think both of which have held to be fair, but you do need to look at the circumstances of the case. And I think tribunals will be slightly aware of the idea that it could be very easy for an employer just to put everyone at risk and ask them to apply for new jobs. So rather than selecting from a pool of individuals, so you just need to be, I guess, careful to look at the facts of your particular case and select what's going to be right in those circumstances. Yeah. I mean, in effect, I suppose the job applications, while they will filter some people out, if everyone applies, you're still going to be in a roughly similar process.
I think it works well when you genuinely have an entirely new set of jobs, when your restructure is one that involves a full change from all of the old roles to entirely new roles, and you can evidence that. The main risk of adopting that approach is when you try to use it for something where essentially all you're doing is a reduction in headcount. It's just not it doesn't work for a headcount reduction situation. In my view, it's not apt for that kind of process. So, and there's a spectrum there. So it's either a headcount reduction or a change in roles. There's a continuum of degrees of change in the nature of a role, and you can fit somewhere along it. So, as with so many things, it's very fact specific. But an advantage of what you've called the selecting in option is that it's not subject to the same stringent assessment of fairness of selection criteria that applies in a redundancy situation, and there's some quite clear case law to that effect. So where it's an appropriate approach to use, it actually gives you a bit wider discretion in the criteria you use to assess the recruitment.
I think we've reached the end of our allotted hour, and thank you all very much for listening. What we may try and do is provide some very short sort of responses to each of the questions that's come in afterwards. I'll need to talk to our technical people about how that might work. But anyway, leave that with us to see what we can do, because there are a few more questions we've not got to. Otherwise, as I say, thank you very much for listening.